And it also had a lot to say about attorney discipline, which is interesting because under New Jersey law, when an attorney gets something that on its face is subject to privilege, the lawyer has an obligation basically to stop looking at it and tell the other side. Didn't happen here. So the case is remanded to the trial court by the Supreme Court to see if the defendant's attorney should be disqualified. Two decisions, one in the public area, one in the private area. You can look through the law of all the states to see how states approach the public-private employment area, Julie.
Let's move on to attorneys and clients. Qualcomm certainly sent a shiver down corporate America's spine. So can we discuss that a bit and how the interaction was between outside counsel, in-house attorneys, and employees at Qualcomm?
Well, there's a lot going on in Qualcomm. Qualcomm's a patent infringement action. There comes a question as to whether the plaintiff had participated in an organization that set certain standards. And if the corporation the plaintiff had, it basically can't assert patent rights based on its participation or from things arising out of the participation. They're a trial. The plaintiff has a corporate witness on the stand. Apparently direct went very well, and on cross-examination, a question asked whether she was aware of any communications or participations in this organization. She refers to 17 or 21 email. Judge stops the trial. It turns out that in the course of some discovery, Qualcomm had thousands, tens of thousands of email communications with this organization. Judge invalidates the patents. Judge imposes $8 million of sanctions. And for the lawyers who are listening in, most interesting or most ominous, the judge refers a number of attorneys for hearings on whether or not they should be referred to the California disciplinary authorities for violations of ethical rules. Long story short, because of the time, the April decision here by a magistrate judge says, I think there's blame here all around. Outside counsel might have not asked the right questions. Inside counsel, the corporate people might have disclosed everything. Decides not to impose any type of reference. In the meantime, California had done some things on its own. The saddest part of this decision to me is if you read the affidavits that were submitted in advance of the hearing that led to this April order, there's one young associate who apparently was very promising and says in his affidavit or declaration, you know, since this has happened, I can't get a job. Probably one reason being you can Google him and find references to him, Julie. So
not the best way to start your career.
I think the lesson in this is, you know, you're in discovery. Whether you're looking for electronically stored information or not, you need to have a dialogue with your client, but especially with the SI. You need to know where it is, you need to know what it is, and you need to know whether or not that's the type of information that should be turned over to the other side. It's a cautionary tale.
It is certainly a cautionary tale, and it definitely shows that the bar has been raised for attorneys in terms of understanding and knowledgeably being able to discuss electronically stored information and being able to have a conversation with their client that results in receiving adequate information that's responsive to discovery requests. And speaking of technology, we should probably move on to the next slide, which is the drive to new technologies, and talk about some commercial reasons. But as we start out, Ron, let me ask you, why do we care? Why do we care about the new technologies, and why do we care about the implications that are held in the commercial world?
Well, number one, everyone's being driven to use these technologies. Cloud computing really just means that instead of doing work in-house, you're having it done outside. Simplest way to describe it. There are economies that drive organizations to do that. Government agencies are being driven towards that. For one reason, the Obama administration is looking to making the world of government more transparent, to save monies by using clouds. Social reasons, obviously, most people in the world have some type of Facebook account or the like. Corporations have Facebook accounts or web pages and the like. And then the other simple reason is there's so much electronic information because everyone communicates electronically now, Julie. So there's a lot of reasons why organizations, private and public, and individuals are going out to the cloud, going out to social media. And there's just a rapid expansion of information.
Well, as we get these new technologies, clearly what comes along with it, as always, are new legal obligations. So one issue that I've seen come up quite frequently is, what is sufficient now to establish personal jurisdiction?
The Buckles decision on the next slide is, again, another recent decision. And it really talks about if you direct a subtype of website or the like into a particular jurisdiction, whether that's enough to establish personal jurisdiction that's consistent with the 14th Amendment. We don't have that much time to go into it. Just suffice it to say that what happened in Buckles is there's a website created, there's some information that comes out on the website, and really what you have here is an impersonating blog with false LinkedIn account and the like to damage the plaintiff's reputation. And the court said, look, the conduct of the defendant was purposeful. It was aimed at the forum, which was here, Utah, where the plaintiff lived, and there was no reason why you can't exercise specific jurisdiction over the defendant. Also, interestingly, there's a corporate defendant. The court finds that the individual defendant was acting on behalf of the corporation, and you could exercise jurisdiction further than just the individual defendant. A lot going on here. Failed family relationship with a company, contracts terminated. As I said, the brother creates this impersonating blog. I think the answer, if you read Buckles, is, look, you create something. It's directed, whatever that means, towards a specific jurisdiction. The jurisdiction can assert, that jurisdiction can assert power over a defendant. And the other things going on here in the world of technology, ephemeral information, a perfect example of that is random access memory, Julie. These decisions you see here basically said, look, the information is relevant. The information is something that can be recorded or the like or found. We're going to impose an obligation on the defendant to produce ESI in the form of ephemeral information. Ephemeral as opposed to stored, whatever that meant. And then the last, we have this bullet point about rights and obligations of employer or employee in the 21st century. I think you're going to see, if you read Stengart and Kwan, courts are going to be looking to the contractual relationships between an employer and employee, what an employee is allowed to do and not do, and whether or not there need to be some carve-outs to protect attorney-client communications, and Stengart to talk about that. So I call this new legal obligations. I don't know that they're really new, but I think what you need to do is look at these new technologies, draw them into existing precedent, and decide whether or not there are certain things, requirements that can be imposed on a party, even when they're dealing with new types of ESI or new sources of ESI.
So we see how the drive to new technologies, no, I was just going to lead us into the next slide. Our drive to new technologies leads to the potential and not quite defined new legal obligation realm, but certainly lends itself to new legal principles that we've seen arise.
And one thing you would look at is Rule 34A of the federal rules that has a concept of possession, custody, or control. I think this is particularly interesting when a corporation uses a website that it's not hosting, or when it goes out to the cloud, and whether or not you can control or get access to information that that third party is keeping. That's really the second bullet point here. When can I, as a party, be required to produce something being held by someone else, especially ESI? The Innis Arden decision is here. Innis Arden is not about ESI. It's an environmental case about whether a consultant of a party had an obligation to maintain information within the scope of a legal hold. The answer is the court looked at the contract. The court said, look, there's a contractual obligation here. Because of the contract, you party have control over the third party keeping information, and there can be sanctions imposed. Agency and authority are just here because these are traditional concepts that everyone who's a lawyer knows about them. But I think courts are going to be looking at agency and authority principles to decide whether or not a party can be compelled to produce information that someone else has, Julie, that may be out in the cloud or that may be on some social media that the party has access to or the party is using for one thing or another. There's a lot here. Stay tuned. We're going to have more.
Certainly there is, and I've seen recently issues come up of the third party that is hosting information, such as a co-location site that's managed by a third party. The issue of that particular third party has its own contractual obligations to its clients. So again, interesting area. We'll see a lot of evolution in this area as people move more towards the cloud, I believe.
And then let me just move on. We've got a few minutes left, and I know we want to cover everything. The next slide talks about satellite discovery. This is discovery about discovery. It's in a sanctions context. If a party fails to preserve ESI, the other side is probably going to seek depositions or interrogatory answers or the like from that other party to find out what happened and why. And then waiver of privilege. Again, there may be discovery unless something can be worked out between the parties, Julie, to find out how reasonable the other side was in attempting to produce information or doing a privilege review. So that has the potential of driving up a lot of cost. And you'll see here the legislative history of Rule 502 says one of the things we are concerned about is the cost of review of ESI for privilege purposes. The Hobson decision is in here, written by Paul Grimm, a precursor to, if you will, Rule 502.